welcome everyone to today's meeting of the GLA Oversight Committee. I welcome those who are in the chamber, those in the gallery, and of course those people who are watching this broadcast online. Can I remind everyone to put their phones on to silent or turn them off, please? Even on vibrate, it can be picked up by the microphones. And can I ask the clerk to confirm any apologies for absence today?
Thank you, Chair. Apologies for absence have been received from Assemblymember Deval, for whom Assemblymember Cooper is attending today's meeting as a substitute.
Lovely. Welcome Assemblymember Cooper to our meeting today. Declarations of interest. Can we note the list of offices held by Assembly members? And can I ask members if they've got any other disclosable pecuniary interests on specific items listed on the agenda today? Noted. Lovely. Thank you. Minutes. Can we confirm the minutes of the meeting of the Oversight Committee held on the 22nd of July 2021 to be signed by me as a correct record? Agreed. Thank you very much. Item 4, summary list of actions. Can we note the completed and ongoing actions arising from previous meetings of the GLA Oversight Committee?
Agreed.
Thank you. Item 5, action taken under delegated authority. If I read out what the action is, and Assembly Member Best wants to speak on it. So we're being asked to note the recent action taken by myself as Chair of the GLA Oversight Committee under delegated authority in consultation with the Deputy Chairman, Party Group Lead members and the Chair of the London Assembly, namely to ratify a letter to the Mayor from the Chair of the Assembly regarding Pride in London. Assembly Member Best, you wanted to raise something on it.
Thanks, Chair. And I think it's important to point out at this moment that that letter written on the 16th of July is now, and references the Pride weekend that should be this weekend, the 11th of September, is now unfortunately outdated insofar as on the 6th of August this year, Pride in London was cancelled. And obviously this represents a real tragedy for our LGBT plus community in London. I know personally for myself, Pride as a young teenager was the first time I felt accepted and comfortable in my sexuality. And now with a young family, it's the time that I get to show my children that there are other families that exist like ours. And it's such an important time that we can't get back. I wanted to also raise that there wasn't a call by the community board when they resigned due to issues, allegations of bullying, that they wanted an investigation by the Mayor into Pride in London. And I hope perhaps as this committee it's something we can bear in mind for future, looking into Pride in London, what's happening there and making sure that this doesn't happen again, and in 2022 we can have a fantastic event.
Thank you. Well, we can pick that up, see once we get the response. And actually, it's an issue I've been taking up, and I've got a meeting with officers in the next week or so about. But yes, let's look at how we can take that up. But are we happy to note the action that I took in the summer?
Noted.
Lovely. Thank you very much. Right, let's move on to item 6, which is our main item today: London and Partners and GLA Governance, GLA Code of Conduct. I'm delighted to welcome our 3 guests today. We've got Emma Strain, who is the Monitoring Officer at the Greater London Authority. Welcome, Emma. We've got Paul Hoey, who's the Co-Director of Hoey Amesco Associates Limited, who's an expert in this area. Welcome. And in the middle, Jonathan Goulden, partner at Wilkin Chapman, also an expert in this area of Code of Conduct. Thank you so much for joining us today. This is the first of 3 meetings which is going to be looking into the governance at London and Partners and the GLA in relation to overseas visits and trade delegations. And the purpose of today's session is for the committee to be provided with information to make recommendations on whether the GLA Code of Conduct should be reviewed and potentially strengthened, as well as considering the need for better communication of the code. And just to put on record so it's very clear for the benefit of those who are watching the meeting, it's not permissible for the committee to purport to be investigating a breach of the Code of Conduct, for it to draw conclusions about whether conduct amounted to a breach, or give the impression that we are disciplining the former Mayor of London. So just to be very clear, that's outside of our remit. So welcome to our guests today. We're delighted to have you with us, and I'm going to start the questioning, if I can, to you, Emma, as Monitoring Officer. Can you outline for us what the Code of Conduct does and does not cover?
Of course. So the GLA is required in legislation to have a code of conduct. It applies to the elected members of the authority, so that's the Mayor and the 25 members of the Assembly. It it also applies to the Mayor in his capacity as the statutory office holder of MOPAC, the Deputy Mayor of Policing and Crime, and the two GLA independent persons. It sets out how each member should behave in conducting their roles, and it's part of the GLA's ethical standards regime. The code incorporates the Nolan principles of public life and sets out obligations on members, including things like treating others with respect, not disclosing information inappropriately, conducting oneself so the authority is not brought into disrepute, and it also includes requirements to register and declare personal interests and gifts and hospitality. The current code has got a series of related documents associated with it, including a unified planning code of conduct and a procedure for handling complaints, both under the code of conduct and under the police and crime regulations. And each of the elected members and people I spoke about above signs up to adhere to that code of conduct when they join the authority as an elected member. So in terms of where we are now, so the code dates back to 2012, which is when the legislation was changed. I came into this role in October 2017, and in March 2018 we made some minor updates to the code in relation to some allegations of sexual harassment within Parliament and within the media industry, which I'm sure many of us will remember. We updated the code then to ensure that sexual harassment was explicitly addressed, and also that the Bribery Act was addressed at that time. In 2019, in response to the work of this committee, the Chief Officer and I did some work around registers of interest and the registration of interest and gifts and hospitality related to staff. And that was particularly looked at the importance of non-pecuniary interests and set out additional requirements for staff in that area. And at that time, we noted that the code, as it stands, doesn't include sufficient information about those other kinds of interests, so non-pecuniary interests. But we agreed that actually a future review of the Code of Conduct would look more closely at interests. We had intended to do this review of the code in 2020, around the time of the original planned mayoral and London Assembly elections, but that was then delayed by COVID, and so we're at the point now where we're ready to undertake that review. So in terms of the areas that I think that we need to look at as part of that, would you like me to go on to that, Caroline, or am I getting ahead of myself?
I think you're getting ahead, because our next section is the review of the code. This is this for all the guests, and the final section's on benchmarking the code.
So shall I pause there?
Do you want to pause there? And I'm just wondering, in terms of you've got the code, but also alongside the code, you've got the 7 Nolan principles of public life.
Yes.
So how do you ensure that that is properly covered in your work?
Yeah, and those principles form part of the code explicitly. So. And when I talk to members about the code, particularly when they join the authority, that's one of the key principles we talk about, that there are the 7 principles are set out to sort of govern behaviour, both of members but also of all public officers, including myself.
Okay, lovely, thank you. Let's move on then. Assembly Member Cooper.
Thank you very much, Chair. Emma, thank you for being with us today. I just wanted to ask a little bit about any lessons that might have been learnt regarding the GLA's Code of Conduct following any minor breaches that have occurred. And one that springs to mind was the issue of the appointment of Helen McIntyre, who was appointed in a voluntary fundraising role on a project for the Olympic Park visitor attraction. And the former mayor was deemed to have committed a minor technical breach of the Code of Conduct, although I understand that was because he misunderstood the language used in the code. So what lessons have we learnt from that? Have we tightened up the language? Have we made any improvements?
My understanding is that happened before the current code was in place, because that was under the previous regime in terms of standards committees. So I wasn't around at that time, but I think for me it's in terms of what we learn as we go through these things. And I think part of the issue for me with the current code is that we haven't taken action to look at previous complaints that have been considered both by me in the last 3 years and prior to that. And we don't have a process for the code becoming a more living document. So I'm sure Paul and Jonathan will talk to this, but one of the recommendations I know that has been made by the Committee on Standards in Public Life is that there's a regular review process of how often that you update the code and the things that form it. And so we haven't done that, and there's an opportunity for us to do that and to programme that going forward, so that there is a more active process of learning from the experiences and building that into the code.
We haven't had a sort of a regular review going on then
No,
up
we
until
haven't.
now. So has it ever been reviewed
On
a regular basis? No.
Not since I've been doing this role. We made some minor updates in 2018, as I said, but there isn't a schedule that says we will review this document every 2 years, for example.
Okay. So how does the code address the reporting of interests, both pecuniary and non-pecuniary?
Okay. So it does include quite detailed information on pecuniary interests, and that they are set out explicitly and quite clearly in the legislation as well. So it provides details of how members should go about declaring those and the various categories set out in the Localism Act. The code also refers to the way that members should think about those pecuniary interests in meetings. So meetings like this, for example. I know that in the beginning of the meeting, Caroline talked about that as part of that beginning session. What it doesn't do is say very much about other interests. It doesn't provide adequate coverage of how what constitutes another other interest and what the requirements are of members in declaring other interests. We also don't provide any guidance as to how that would help people to think about how to interpret that. So
You're saying you feel it's inadequate in terms of what it requires you to do for the non-pecuniary
Yes.
interest. Because
Yes.
obviously I could have a non-pecuniary
Yes.
interest, but I've got a friend who's
Yeah.
doing something and, I might not declare it, but is a friend of mine and I could be smoothing the path in some way towards something. It's a completely hypothetical point that I'm making, I'll just say.
Yeah, exactly.
Obviously I have no friends, so it's obviously completely hypothetical. Yes, there's various
I'm
people
sure that's
laughing.
not true. And I guess the one thing to say is that the form that we fill, that members fill in, does include a box that is the kind of and anything else you'd like to consider box. So box 11 on the form captures that. But what it doesn't do is provide that guidance, provide that structure. So there is no help provided to members in exactly that example that you gave, and that is, in my view, something that we do need to correct. And we have done that correction for staff as well, where we define in the staff code connected persons, for example, and we talk about which family members we would consider to be connected persons.
Coming back though to the pecuniary side,
Yeah.
which I think is the bit that most people are probably the most concerned about, what type of relationships with other individuals would require the declaration of a pecuniary interest? And you've just mentioned the concept of the connected individual. Yeah. I mean, is that obligatory under the current Code of Conduct?
It depends on which interests you're specifically looking at, but on the whole, most of the areas look at both the individual and then a person that you live with. They don't necessarily broaden out to your second cousin or a close family friend.
So if I'm having a relationship with someone, I'm having an affair, let's say, but it's someone who doesn't actually live in my house with me on a permanent basis, perhaps visits me for obvious reasons, and I perhaps visit them, would I be obliged at this moment in time, or indeed the mayor or any other assembly member, would I have to declare that under the current Code of Conduct? It's not someone who's living in my house.
I think the question I would be asking myself in that scenario is how does that relationship impact on my decision making? And the things that are important are and that's where for me the Nolan principles comes in, because those principles talk about integrity, they talk about honesty, and they talk about and therefore if there is a decision that you are taking that you should not be taking, then you should not be taking it. I don't think it's right to say that the registration process is designed to talk about somebody's personal life, but where your personal life comes into play with your official role, then that's where careful thought needs to be given and more guidance needs to be provided.
Well, yes, it would be quite awkward, obviously, if I was, in a civil partnership with someone and I was having an affair and I had to declare that as well, because obviously that might then become apparent to the person that I was in my partnered relationship with and living with. So I can see that that would be quite an intrusion into someone's personal life. What kind of other relationships with other individuals would require the declaration of a pecuniary interest, do you think? And is this something that can be nailed down in a code of conduct?
And I think there is a danger of trying to nail things down too much, because, of course, for everything that you try to nail down specifically, by making things very restrictive, we will naturally have missed something. So there is something for me about not nailing things down so tightly that it is very clear that everything is either inside or outside, because it is for the member to think about whether that interest is something which could be perceived as having a conflict with their role.
So it's partly about the perception as well.
Yes.
But it is also about the requirements, isn't it? So if I am having this mythical affair with someone who doesn't live in my house, at the moment, if that person was applying for funding from the GLA or any other part of the GLA family, would I be obliged to reveal that fact? I mean, I might be assisting them or, helping them with their application form.
I think if you felt that the decision that you were taking was being compromised by a relationship that you had, then you shouldn't be taking it. That's not the same as putting things on that's not the same as writing things on the form necessarily, but people have to live by those principles throughout in their time as a member, and when taking any decisions, you have to be thinking about whether the decision you're taking is appropriate. So it isn't just about whether, if I put it on the form, that gives me the ability to say, I don't need to think about it again. The decision making, having registered an interest on the form, doesn't mean that you then park it. You have to then think about how that would be, how that would relate to a decision that you're taking associated with the authority's
Yes,
business.
I often think about the man on the mythical man on the Clapham omnibus, because it obviously leaves from Clapham Junction in my constituency. But the question I'm asking is not about the perception of the man on the Clapham omnibus. I'm asking about, would it be required under the code? And I think what you're saying is it would not. It would be up to me to exercise good judgment if I thought the perception of this mythical man was going to be such that they would be at least raising an eyebrow. Yeah, okay, thank you. Do you think that potentially leaves us in a slightly difficult place if we do administer a great deal of funds in this building, assuming that quite a few of us do have friends, not necessarily even people that we're having affairs with, and yet we're not obliged necessarily to declare that situation? If someone is applying for funds, that could be awkward in terms of perception. Yes. Thank you. I thank you, Caroline. I think Joanne might want to
Assemblymember
join me.
McCartney.
Yes, thank you. Can I just widen this out to Mr. Goulden and Mr. Hoey, if I may, and just taking up where my colleague has left off. The GLA Code of Conduct does not require members to disclose pecuniary interests of close associates, which is in conflict with the Nolan principles. I think quite clearly that says that they must declare and resolve any interests and relationships. And I note that, from the notes I have, that the obligation on the mayor to register pecuniary interests of a close associate was removed from the mayor's code of conduct in July 2012. Should it be put back in, do you think?
Can I take those questions? First of all, when you talk about July 2012, that was when there was a national code of conduct which applied to all councillors, and that was abolished under the Localism Act. Councils had to simply adopt their own code of conduct. So it's a different situation legislatively from where we are in July 2012. What I would say in relation to that particular question, if you look at the Nolan principle of honesty, and as Emma has said, the Nolan principles are built into the code as part of the code. It says that holders of public office have a duty to declare any private interests relating to their public duties and to take steps to resolve any conflicts arising in a way that protects the public interest, which is all fine as a statement. Now, what the Committee on Standards in Public Life themselves would say is that the principles of themselves are not necessarily enforceable. They need to be translated into rules. Some codes of conduct, and the work that we have done with the Local Government Association has attempted to expand that to say what is meant by a private interest, and how do you go about resolving any conflicts? Because here, that principle is a general principle, but it doesn't give a member any specific guidance, as to what is meant by a private interest. It clearly goes wider than disclosable pecuniary interest, because it talks about any private interests, but then your code failed to define what any private interests might be. And I think when we look at other codes of conduct, and when we look at the work that we've done with the Local Government Association, we have attempted to define what any private interests are, and that would be, for example, the interests of your sister, etc., etc. But members, in our experience, then need specific rules, because if it's left, for the member themselves to resolve that without any guidance, that's when it can be difficult for a member, to work out, because you can come up with two different answers. One person might think, well, I've resolved this in the public interest. Another person with the same interest may think, I've resolved it in a different way. And that's why we tend to look for codes that go into greater detail. But the Localism Act only required councils to put what are called disclosable pecuniary interests. Those are the interests of you and your partner, or the person that you live with in a relationship. It's not just people you live with, because you could live with your children, but it's simply people you live with in a relationship. The Act didn't go any further than that, and the GLA Code in 2012 didn't go any further than that in terms of defining the rules. So you can look back at the principle and say, under the principle, I have to declare any private interests, but there is then no guidance, as far as I can see, as to what may or may not be a private interest. Is it, is it a third cousin twice removed? Is it somebody that lives 3 doors away from me? All those sorts of things. So that's where we would look to see that I think that there are needs to strengthen the code, or at least to make that principle understandable, if you like. So there's like almost a formula you can put a test through. This is the interest. Does it meet X, Y, and Z tests? And those things that you would look at normally would be things like, for example, clearly if it relates directly to your interest, if it's your, it's either your application or it's your sister's application, but it's then when you get into areas about how far are people affected, if it's 3 doors away, if it's next door to where your sister lives, if it's all those sorts of things, and that's really where we would look for members needing much better guidance and a sort of almost formula you can follow in the code.
So in the situation where someone is having an affair, they're not going to disclose it in advance on our regular disclosure of interest. I think, that's... could there be guidance issued for that scenario? It seems to me very difficult and unenforceable. So what should a person do if they are making a decision?
Yeah.
And it directly affects not their partner, but their a person they're having an affair with. What should they do?
The term that we tend to use is a close associate, and that can cover a whole range of things. It can cover friends. It can cover, indeed, I made the comment to Jonathan before that the rules that govern officers here, for example, talks about friends, but it doesn't talk about enemies. And they can be just as, you can be just as keen not to award them something as it is. So I think, the term we would look at is really a close associate, and then you would look at, is it somebody that person is associated with in more than a general way.
And then just teasing this a little further, if it's me, I'm not making a decision, but I'm aware that a close associate is banding my name around, trying to get funding or other things, is there a duty on me there to do anything from my organisation?
I would say under the code, nothing would necessarily arise, that you can't do things about a third party necessarily.
But if it was to my own organisation, another arm of my organisation?
I think what I would say, again, what one is tending to look for in a code of conduct is to say, is this a decision which is, either relates directly to me or whoever, or affects somebody close to me, and then are they affected more than the majority of people, and what would a reasonable member of the public think? And again, a lot of that will depend on the nature of a decision, and it's very hard to give guidance on any individual case. what you would look for is a formula that you would go through, and then, you know, our advice would always be to members then seek advice of the monitoring officer, essentially, who would, you know, is there in proxy of the reasonable person, you know, the man on the Clapham omnibus, the informed man on the Clapham omnibus, if you like. Yes, yeah. So, you know, we would say that you can't write a set of rules which covers every possible situation, and you can't even give guidance which writes every possible situation. What you can do is give almost a flowchart of decisions for people to go through in their mind, and then when you reach the end of that, you think, well, I've still got some doubt here. That's when you would then go and seek some advice, I think. So, we can't comment on individual situations. Obviously.
If that objective test had been made, I should go and get some further advice.
The more objective you can make the test, the better, obviously. But there will always be some subjectivity in anything.
Thank you. And can I just go back to Emma briefly, if I can? A former monitoring officer who oversaw the review of the Code of Conduct told the IOPC's Operation Lansdowne that he gave out additional guidance to members that they were not required to disclose the pecuniary interest of close associates so long as they have nothing to do with the GLA. But he then went on again to reiterate a test of an objective member of the public. Is this something that you're looking at and seeing how you can incorporate it into the review?
And I think part of the review of the code has to be then once we change something, we need to make sure that everyone is aware of it, and therefore that how we provide, you know, information training to members should be part of that process, and what we do with it. So this following the elections this May, for example, I met with all of the new Assembly members and, you know, shared the code with them, talked to them about the code, talked to them about my role, talked about interests, and gifts and hospitality, and all the parts of it. And there is nothing to stop us making reviewing that element of guidance as well as part of this work. I think it would be a sensible thing to do.
And perhaps I could ask Mr. Hoey again. Obviously, I have a duty to disclose interests, either pecuniary or otherwise. But what if, and this is hypothetical, what if I'm aware that a family member or a close associate is doing something they shouldn't be doing, and it affects my organisation? Am I under a duty to report that?
I mean, my short answer would be no, you're not under a duty to report that. I can't think of any legal duty why you would have to report that.
There isn't?
No.
No.
Unless...
Okay, I'm just wondering whether we should be looking at that as well, Emma. Might be something to do. Yes, Mr. Goulden.
Yeah.
May I follow on
do.
from some of Paul's comments, Member McCartney? The current code, bearing in mind it was adopted in 2012, is actually relatively fit for purpose, in that it covers some of the key aspects of a requirement to treat others with respect, not to bully, not to bring the office into disrepute. Where there is a gap is that the only form of interest which is specified under the code is a declarable pecuniary interest, the definition of which is highly limited. And in planning terms, if I have a planning application on the house next door, I don't have a DPI in that planning application, because you can only have an interest in relation to what you have on the register. I'm only required to register number 2 Acacia Avenue, where I live, and if there's a planning application on number 4 Acacia Avenue, I don't have a DPI in it. Now that doesn't really fit very well with what the public would expect, and it doesn't fit very well with what the monitoring officer would expect in terms of mitigating the risk of challenge by judicial review of bias on the planning decision. So many local authorities have supplemented their code by incorporating some description or other of an other type of interest. whether they've called it other significant interest or pecuniary or non-pecuniary. And the Local Government Association Model Code of Conduct does provide a number of types of other interests. I think there are two working examples that show what that could be for the authority. First of all, the previous Code of Conduct, Model Code of Conduct, the National Code of Conduct, which existed until 2012, talked about close associates. And Paul has mentioned, he's used that phrase, and has highlighted a close associate can arise for a number of circumstances. It's a good, flexible phrase. It can be an enemy, and that's a very important point. So it can cover a variety of scenarios. Secondly, the GLA staff have a working definition of what's called for them a significant disclosable interest. And that includes, so the following are defined as connected persons, and I'm not going to go through all of those, but one is other persons with whom the employee has a business relationship or some other significant business, social or personal connection. And I think it's, frankly, if you're asking your staff to adhere to a certain standard, it would be reasonable for you to consider adopting something similar for members. So I think that's the key point I wanted to make on the code. It really does need to incorporate some other form of interests. Paul may have some specific comments and some other areas where your current code perhaps might pick up some points which we've highlighted in the LGA model code. But I'm saying that that's the most important area to cover.
Yeah, I think that's helpful. Yeah.
Thank you. Could I just pick up with Emma then, just to clarify, if I've understood your discussion, that there's no guidance or information currently given to members about potential conflicts of interest that are non-pecuniary at the moment, or will you give advice if a member comes to you, and have you provided that advice?
So when I spoke to new members, I talked about non-pecuniary interests, because of course there is a box on the form which has been used to put information into, but there is no formal guidance within the code, no, and that's the thing I think we need to correct.
A weakness at the moment. Lovely.
Yes.
Thank you very much.
Sorry, Chair, can I just ask, do you mind? Yeah.
No.
I suppose it's the definition of what's a pecuniary interest as well. Is it, in a public authority, is it just the granting of funds, or can it include the reputational benefit that comes by being involved in something?
Briefly, Chair, a pecuniary interest is something to do with money.
Yeah.
So if you were to have a other form of interest, so just correct me if I'm wrong, Paul, I think the LGA model code deals with pecuniary and non-pecuniary.
We talk about disclosable pecuniary interests because the Localism Act requires them, and we couldn't work around that. We then talk about other registrable interests, which are outside organisations, you remember. So disclosable pecuniary interests in essentially cover the financial aspects of your life, which includes paid directorships, for example. Other registrable interests, we've extended the register, so it covers what you might call the voluntary side of your life, so unpaid directorships, charities that you sit on, etc., that you're a member of. We then talk about non-registrable interests, which are the interests of your family, close associates, because you're not expected to go around and, as soon as you get elected, to say to your brother or your brother-in-law, I need to register all your interests, because they're not in the public domain, because that's not, they're not the elected person. So we talked about non-registrable interests. What the LGA code also talks about is things which relate to or affect your finance or well-being. So it goes beyond pecuniary. Clearly things that affect your finances, fairly obvious, but the term well-being is used in two aspects. I mean, there will be things that it's arguable whether they have a financial impact on you. And again, if we keep going back to planning, apologies, but we work a lot with, planning authorities, etc. So, an extension going on the house next door may actually have no financial impact on you because your property price is so fluctuating anyway, but it will have some impact on your well-being potentially, or, if your street is going to be closed for 3 months for road repairs, that's going to affect your well-being if there's going to be drilling going on all the time. So it expands the concept beyond what you might call pecuniary to talk about finance or well-being. So, if it relates to or affects the finances or well-being of you or a close associate.
It's a means of trying to codify
It's difficult,
that view of the person on the Clapham Omnibus.
Yeah.
To codify what I call the sniff test, does it smell right? And it's quite difficult. It's quite interesting what you're saying, actually. It's not quite how I'd always define things. But I've got Assembly Member Russell next.
Thank you, Chair. So I've got questions for Emma. How has the Code of Conduct evolved over the last 20 years?
So, I'll be honest, my exposure to this has been really in the last 3 years. So this code has existed for my time in this office and dates back to 2012. And before that point, of course, we're on a different standards regime, and that's where I've turned to my learned colleagues because I have not been involved in that process. So, if that's okay.
Well, can I pick up the first sort of 17 years of that case of that? I'm sure you were given a resume of me, but I used to work for an organisation called the Standards Board for England, which was a national regulator set up under the Local Government Act 2000 as a response to a report from the Committee on Standards in Public Life. And I actually worked there. I was actually employee number 1 at the Standards Board, worked there from 2001 till 2012 when it closed its doors. Under that Act in 2001, there was a national code of conduct which applied to all councillors, from a parish council up to the Mayor of London. Every councillor in the country had the same set of rules applied to them. When the Localism Act came in, it got rid of that national code of conduct on the basis that the thinking was each local authority is essentially sovereign and can determine its own rules of governance, and therefore the Act simply said you must have a code of conduct, but what is in that code is entirely up to you. Apart from it must be consistent with the 7 principles of public life, and it must contain disclosable pecuniary interests. And as we've talked about, there's a very narrow set of interests. That was the only guidance given by government, and therefore you were told to go away and write your own code of conduct. Now, there were 2 different approaches to codes at the time. There was the old national code from 2012, which yours broadly resembles, certainly in the first part, around behaviours, which is a set of rules. So you take the 7 principles and you translate those into rules. So these are the principles, and that means the rules are: you do not disclose confidential information, you treat people with respect, you don't misuse council resources, etc., etc. Another approach which was taken by the Local Government Association and by Department for Communities and Local Government in 2012, they developed a model code which wanted to be seen as far removed from that as possible, because it wanted to be seen as this was a break from the old standards regime. So they, in effect, adopted a parliamentary type code, which is much more principles based. So it doesn't actually have any rules in it. It merely has a statement of principles in it. So things like you must take decisions in the public interest. You must represent all your constituents. Well, I don't know how people are expected to do that, because any decision you take will affect somebody in an adverse way or what have you. I think that sort of approach fundamentally misunderstood the role of local authorities, in that what one does in Parliament are fairly strategic, what one does in the GLA are fairly strategic things, I imagine, whereas what one is doing at a local authority level tends to be much more about impacting on individual rights, and therefore having a rules-based approach seemed much more appropriate for that. Now, the GLA, to its credit, followed that rules-based approach broadly. Other councils we know, in fact, we've worked with a council where its code is simply the 7 principles and nothing beyond that, which is almost impossible to operate and to determine. When we were asked by the Local Government Association, the Committee on Standards in Public Life, when it reported in 2019, said that certainly the old LGA model code was not fit for purpose. It didn't cover the right areas, and they also expressed concern that a lot of codes they reviewed didn't cover interests appropriately, as we've discussed beforehand. So they asked the LGA to go away and draw up a new model code of conduct, and my company was commissioned to work with the LGA to do that. And essentially, to cut a long story short, we have reverted back to a code which looks much more like the old national code, because that was a fairly comprehensive set of rules, fairly comprehensive set of interests. Members found it a lot easier to understand. So that's the journey the Code of Conduct has gone on. Now, the LGA Code is not mandatory because it would need a change in the law to say all councils have to have it. And I think the committee was keen just to say, produce a better model, and don't worry if it's not mandatory, but it would be recommended. So that's the journey that's happened nationally. Now, I mean, what's happened at the GLA, I think, is you adopted the code in 2012, and beyond the tinkering at the margin, shall I say, that Emma has talked about, it's not really been reviewed until this time. And, you know, I think what Jonathan and I are saying, we think it's broadly fit for purpose. In the first part of it, it covers the same rules as the LGA code does, different, you know, occasional different word, etc. But the interest bit, we think, is deficient.
There is a journey, a development in codes, in that in 2000, concerns were more about, broadly speaking, about corruption. There've been a number of high-profile examples of scandals in local authorities. I was on the internal inquiry team at Doncaster Borough Council. As time has gone on, actually there's more of a focus these days on behaviours. And social media did not exist 20 years ago. And things like social media is an example of something where best practice moved quite quickly. And one area which I think the Assembly could usefully look at is in the current code there is a have regard obligation. The current code, members are required to have regard. I'll just turn to it. So, a little bit of detail. It's paragraph 6, subsection C. You must have regard to any local authority code of publicity. Now, that's a statutory code of publicity. Some local authorities have said, well, actually, we also want you to have regard to our social media policy, which we will review annually. It's a bit easier to review your social media policy annually than to have a comprehensive review of your code annually. So that is something which I think perhaps the Assembly could usefully look at. And I use the word use the phrase have regard deliberately, because it's not saying you must follow it, but it's quite clear in a situation where a member might have flagrantly failed to observe any part of the social media policy. I think it is also useful, you have the planning code. I think it would be useful if that was treated in the same way. The planning code is a fairly operational guidance. There's lots of shoulds. The code is things you generally must or must not do. Your protocols and guidance are things which you should do. And I think it's helpful to maintain a distinction between your code, your rule-based code, and your guidance. But to say you can't just ignore guidance, there is a requirement on members to have regard to guidance. So that's an example where I think thinking has moved on in those 20 years, and as I say, might be of use to look at.
Thank you. My next question is for Emma again. What is the process by which the GLA's Code of Conduct is outlined to a new mayor?
I haven't done that because we haven't had one since I've been here. But the process I would undertake is the same process I would undertake for new members, which is that the code applies to them, applies to members and the mayor in the same way. So that piece, ensuring they understand the code, understand all the elements of the code, the requirements around register of interest and gifts and hospitality. And then, of course, there are sort of other elements that are connected to the code which apply to the mayor specifically. So things like the requirements around the Police and Crime Committee regulations around complaints, they apply differently. So there will be further information need to be provided to the Mayor on topics like that.
Mm-hmm. Is there any kind of refresher process? I mean, have you had any discussion with the Mayor about the code?
So I have received queries from the Mayor around things like interests and other matters, which of course, as you expect me to do, I would respond to. But I haven't considered a refresher process now.
Mm-hmm. No, I was just thinking, just as a member, actually, it could be useful to have a refresher process, just each assembly term potentially, sort of built into sort of future ways things work. And what do you do to ensure that the Mayor is adhering to the Code of Conduct? So you've obviously said how you answer his questions, but is there anything else you do to ensure the Mayor is adhering to the Code of Conduct?
I see it as the Mayor's responsibility to ensure he's adhering to the Code of Conduct, and if he has any concerns or any questions, then I would expect him to ask them before taking any action or decision.
So it's not a yes. So it's the responsibility sits with the Mayor.
Yes.
Yeah. Yes. Thank you. That's all my questions.
Okay, thank you very much. Assembly Member Sahota.
Well, thank you. I think some of the questions which I was going to ask have been already asked by Assemblymember Russell, but mainly about, I was picking up that you only give training to new members and not to the older members. And I wonder why you chose to do that.
It's not to say that I wouldn't. It was the way that we planned this for this. So when all of the Assembly members took office and the Mayor, there's a set of information was provided which included the code and included introductory information in taking office. I guess my assumption was that those returning members are very familiar with all of this. And actually, if members do come to me and ask questions, and of course I'm here to do that. So it was, again, but we could build that in.
Sitting here this afternoon, I was thinking this is a very complex areas, right? Interpretation. In my other hat, when I as a doctor, right, I'm required to have mandatory training every 2 years or 3 years, just to be refreshed, right, or that I do understand the regulations properly, if things may have moved on, right, that the organisation thinks that it has an obligation to train me, right, and here all the obligations being put upon us as members, right, and I think that needs to be looked at, right, that we make this. So that's one thing which I think I just want to pick up on the issue which Assemblymember Russell is picking up. The other thing is this, that the GLA Code of Ethics requires GLA staff to declare an interest with regards to any person related to them or whom they have a close personal relationship with. The Code of Ethics does not apply to members. As the IOPC's Operation Lansdowne report highlights, this means GLA staff have to declare pecuniary interest of anyone with whom they have a close relationship and who have a business dealing with the GLA. But the Mayor of London and Assembly members would not have to declare pecuniary interest of someone they are in close relationship with. So the GLA staff are having to perform to a higher level than members. What do you think about that?
When we reviewed the staff code, we did acknowledge that this meant that it would be out of kilter with the members' code, and really it's a sort of a timing issue. As to we've always planned to review the code to bring that in, to change those obligations, knowing that there is more that needs to be done in interest of us, as we've talked about today. And this review, I think, will do that. So.
Great, okay. Thank you.
Okay, you've finished your questions. Okay, Assemblymember Ahmed.
Thank you, Chair. My first question is to Emma. I think you may have alluded to this, but if we could go into a little bit more detail. What do you think the impact of a more comprehensive and robust code of conduct would be?
I think it would be helpful to members and the Mayor to enable them to provide them with more guidance, to enable them to think more broadly about what interests they may have and what interests they should declare. And that should mean that actually the business of the authority is better, because we would be avoiding situations where we may receive complaints from members of the public, or where decisions were taken inappropriately, because we've provided better guidance to members on conduct and behaviours and on interests. So I guess from the other thing to think about is, of course, is that in terms of having a code that's clearer, provides more guidance, means that members are better able to have the assurance that what they're doing is the right thing, which I think is really important.
Thank you very much. And my next question is to all panel members. The events surrounding Boris Johnson and Jennifer Akruri's close association during his second term as mayor pose a notable case study of where questions surrounding the circumstances related to a member's actions can arise years after the member has left office. Do you believe that the current GLA Code of Conduct provides us with sufficient powers to enact historical scrutiny where it's appropriate and in the public interest? And I wonder, Paul, if you could start with that.
To Jonathan as our legal representative here, but can I go back to the first question you asked, which was about how an improved, more robust and comprehensive code would help improve standards? First of all, I would say that entirely depends on the members, because we work in councils up and down the country where sadly we probably see the worst of local government because we're only called in when there are problems, and we work with councils which have the best code in the world. They have the best process of case handling. That doesn't stop things going wrong if there's not the proper political and managerial buy-in from the top. So political parties have to take responsibility for you can write the best code in the world for you, but if you're going to ignore it, that's a problem. So I would say yes, by all means the code can and should be improved, but it then needs to be lived, and it then needs political buy-in on that. But at the risk of passing the book, can I ask Jonathan to pick up could we speak as one voice, of course?
The smile between us is because the issue of jurisdiction over a former member is one which we talk about frequently. But I'd like also to just respond to your first question. Drucker famously said, culture eats strategy for breakfast. But you've got to have a strategy to start off with. You need strategy and culture. And by strategy, I mean some defining principles and rules of the road. And that is a key part of risk management and risk mitigation. So, as Paul says, having the right rules doesn't guarantee that the risk of misconduct or controversy is going to be avoided, but it's part of the solution. In terms of jurisdiction, there are a number of situations which have arisen in local authorities where a member has left office before the conclusion of an investigation. And the question has then arisen, what happens? My very clear view, and that I think has been endorsed by, there is a council's opinion taken by a particular county council. The code of conduct applies to a serving member whilst they are serving. You can only, the council, the Assembly's arrangements, which is the mechanism for dealing with allegations, only applies to an allegation. An allegation is that a member has failed to comply with the code of conduct, not an ex-member, a member. There's also, so that's my legalistic argument. The common sense argument is, well, how can you, what lever have you to apply? I know that the current regime is widely seen as having extremely limited sanctions, but there can be no means of applying a sanction against somebody who is no longer a member of the local authority concerned. So I have both a legalistic and a common sense view. But there is legal argument which says that any local authority has, through a combination of the general power of competence and in reliance of a case called Hussein and Sanwell Council, an inherent ability to conduct investigations, reviews, lessons learnt, as long as it is quite clear that what is happening, if it's in relation to a former member, it cannot be under the standards arrangements. And I believe you have received advice that suggests that, you know, this is the process that you're following today. You are conducting, as I understand it, a forward-looking lessons learnt exercise, but that must be very clearly distinguished between a process which follows or imitates the arrangements which you have for determining whether a sitting member has failed to comply with the Code of Conduct.
Emma, before we come to you to answer that question, I just wonder if I could pick up on that. So, effectively, are you suggesting that a certain strain of behaviour could continue if it's not picked up, and that it could almost be an issue of just continuing and getting away with it because if somebody's not picking up, they're not picking it up, it's not being picked up?
I'm not sure I follow you.
So could...
Be careful how you're phrasing this.
Yes.
Yeah.
I'll leave it there then, Chair. Thank you. And Emma, if you could...
If you want to think how you could rephrase it, I'm just a bit conscious there. Do you want to bring the monitoring officer in?
Yes, thank you.
And I think, I agree with what Jonathan and Paul have said in this. The monitoring officer powers are sort of limited by the passage of time. And the Code of Conduct is really clear. It applies when members, the Mayor or the Assembly members, are acting in their capacity as that member.
Yeah.
So the Localism Act is really clear that that the arrangements apply when someone ceases to hold office, then the code no longer applies. So that means that in my capacity as monitoring officer, I would not be investigating something that's very historic. But where there is an example of somebody, as you said, leaving office to avoid something, then that's where there's that little bit of wriggle room. So if, Marina, you were to do something flagrantly terrible around the Code of Conduct and then resign 2 days later, I would still have the ability to look into that matter. But when you're thinking about looking back into history, it's a very different matter.
Thank you. Slightly different.
I think, Chair, to be clear on that, my view is once the member leaves, the authority loses the ability to consider an allegation of conduct under its arrangements. Those arrangements being the very specific processes and procedures which are set out for determination of a Code of Conduct matter. I am saying that it is within the powers of the authority to seek to learn lessons, to receive information, but I don't that cannot extend. Those arrangements cannot continue as they were whilst the member was in office.
If I might, I certainly know that in local authorities, if there's a member under investigation at a point when they resign, even where it might be causing a by-election, that any monitoring officer investigation or standards committee investigation into their conduct would at that point completely cease. So that would seem to be consistent with the local authority approach, if that's useful.
Lovely, thank you for that. Did you have further questions?
Yes, I do. Thank you, Chair. A question again to all of the panel. Does the GLA have the powers to apply the Code of Conduct to previous Assembly members and mayors, or would this require legislative change from national government? And Emma, if we could start with you.
My understanding is it would require legislative change, but I'm not a lawyer and I have one to my left. So.
Very good.
Yes, I don't think it's within the powers of the authority under its current governance arrangement. I think it would require primary legislation. And I would just also add, in relation to what I consider the authority's powers to conduct lessons learnt exercises, that must be in relation to the authority's powers and functions.
Okay, thank you. And Paul, would you like to come in?
But I would concur. I think it would need changes to legislation.
Thank you. And my final question, again to you all. As the IOPC noted in their Operation Lansdowne report, the GLA and mayoral email records have been lost relating to the places awarded to Jennifer Akuri on trade missions and other benefits that she may have received between 2012 and 2016. If we were to extend the length of time for which Code of Conduct breaches could be investigated, would we require a corresponding increase in the amount of time in which records about decisions must be kept? Perhaps you, Jonathan.
The authority under the UK GDPR, General Data Protection Regulation, is required to process personal data fairly, and that includes not keeping it for knowing why it's keeping it for a particular period. And it's typical for an authority to set a retention schedule. It is open to the authority to set what period it considers to be a reasonable retention period, but there must be a reason for that. If the authority considered that records of business relationships needed to be kept for a certain period, if there was a justification for that, then it is a matter for the authority.
Thank you. Do any of you want to comment on that? Emma?
There is the governance processes of the GLA set out what our commitments are in terms of the retention of data. I have to say at this moment I can't remember what they are in terms of how far they go back in terms of mayoral terms, but there is a protocol that sets out what we should keep.
Provide that information afterwards, Emma.
Pardon? Sorry, Caroline, I misheard.
Could you provide that information afterwards, please?
Yes.
Then? Thank you.
Thank you. That concludes my
Did
questions.
you have further questions, Assembly Member?
Yes, thank you, Chair. Thank you. Emma, this question is to you. The evidence gathered so far in the session suggests to me that the Code of Conduct in its current state doesn't provide enough guidance to Assembly members and the Mayor. In terms of lessons to be learnt about the Code of Conduct, the IOPC had access to GLA records regarding the Mayor's export programme and the Mayor's international business programme between 2012 and 2016. We know that not all GLA records have been kept on this. Can you clarify whether all the relevant documentation that you handed over to the IPC will be passed on to the Oversight Committee for our consideration?
So I didn't pass any information over to the IPC, but Mary did. So I'm not privy to what information that was passed over. Certainly, I know that a body of information that we did produce has been released in response to an FOI request, so that's publicly available, and I'm sure that the committee already has it. If not, I can resend it.
I mean, Mary, of course, passed it on as an officer of the GLA, right, and not on a personal capacity. The question is really about will that information be shared with the Oversight Committee so that the members and the committee can deliberate on and learn things from it?
I can see no reason why not, but I don't know.
So we can
is.
request that we should see the information that was provided to the IOPC, both from the GLA but also from London and Partners, yes? Yeah. Would that be helpful? Okay, fine.
Okay. And the next question is to all three guests, right? Is that there is precedence that the London Assembly Oversight Committee summoned Boris Johnson to the London Assembly in 2017 to give evidence to his investigations of the Garden Bridge. Mm-hmm. This is after Boris Johnson stopped being mayor of London, but he was summoned. So as the IOPC noted in the Operation Lansdowne report, GLA and mayoral emails records have been lost relating to places awarded via the Mayor's export programme and the Mayor's international business programme on trade missions and other benefits that individuals may have received between 2012 and 2016. Would it not be appropriate for the committee to invoke the power of summons, again under Section 61 of the GLA Act 1999, to request that Boris Johnson provides evidence in relation to these matters to help the committee identify where lessons can be learned for the future?
I'm going to defer to the monitoring officer's view on this. I said earlier that the governance of the authority and improvements to the governance of the authority, I think, are properly a matter for this body. And of course, in doing so, you may call on any assistance that you consider to be relevant. As to the detail of the section number that you referred to and the ability to summon others, I must defer to Emma.
Okay, Emma?
And I don't know the answer to that question. So,
would you please look into that for me?
Yes, of course.
And report back to the chair of the committee, please.
I think if it was relevant to our investigation, I believe we do have the power to summons if we felt it was appropriate, and it would be a vote on the committee. But we can get some advice on that.
Thank you, Chair.
Okay, thank you. Right, Assembly Member Fortune.
Thank you very much, Chair. Jonathan actually touched on some of the questions I had around social media earlier. I think it was interesting and a bit chilling, actually, when you mentioned about monitoring behaviours. So if I could ask Emma, you know, this day and age, there is no smoke without Facebook, right? So what particular challenges do you have as a monitoring officer around social media?
I think it's... I have received a number of pieces of correspondence from the public about social media, as you'd be unsurprised to hear, over the last 3 years. And, you know, it can be an incredible tool of communication. I think, you know, many of members use it very productively as a way to communicate and to engage with the public, which is really important. Of course, the public don't always agree with what people say on social media, and I think that's completely acceptable. And often they write to me disagreeing with views that people have expressed, as you'd expect. And I think for me, one of the challenges is that the public perception is that if someone's profile says that they are an elected politician, then they must, of course, be acting in that capacity at the time they are putting out every single piece of social media they put out, which, of course, is not necessarily the case. If you're standing in your garden tweeting about, you know, a topic in the news, that doesn't necessarily mean that you're conducting your business as a member of the authority. So often I write back to members of the public and talk and explain that the code of conduct applies when members are acting in their capacity as a member of the authority, and that sometimes means that when they don't like what people have said via social media, that there's nothing I can do about it, or should do about it. I think, I guess the challenge comes back to some of the discussion we've had earlier around, would it be helpful to provide guidance to members about, you know, we do provide some guidance to staff in terms of the use of their personal social media and how they do that. We don't currently provide any guidance within the code, and I'd welcome your views as to whether that would be useful.
There's always going to be an element of judgment about that, isn't there? And
yes.
With democratically elected people, yes, you would hope there was some semblance of judgment.
Absolutely.
Switching to Jonathan, I left that pause there. Switching to Jonathan, is there any sort of nuance or challenge around the fact that staff will have a contractual relationship with the authority, whereas a democratically elected person will not? So a lot of what they're going to adhere to is, in a sense, going to be voluntary, guided by principles. Gotcha.
Let me just... There's so much I want to say on this. I'm just thinking, where do I start? So first of all, I suppose this is all encapsulated by if I write a derogatory tweet about a work colleague, or if a member here were to write a derogatory tweet about a member of staff, and that member of staff were to raise a grievance. The grievance is against their employer. the GLA. And the grievance would be that the GLA is failing to protect them from bullying and harassment. Now, if that bullying and harassment is by another member of staff, there are relatively well understood procedures which may involve temporarily suspending and removing the perpetrator from the workplace. That gets very complicated when it's an assembly member who is considered to be doing the bullying and harassing, because there is no mechanism, formal mechanism, legal mechanism in the Code of Conduct to remove the assembly member from the workplace. Indeed, the assembly member has a right to perform their functions, their democratic functions, by taking part in assembly meetings. This is quite a complicated area, and local authorities have tripped up significantly over this, and there is a well-known case concerning Ledbury Town Council, which got itself in a complete and utter muddle over the way it handled staff grievances, which also covered the conduct of a particular member. They just tried to use a grievance process to actually deal with a member conduct issue. So this is a complex area, and we could spend the rest of the afternoon on this alone. So I'm just going to flag it's involved. Good HR policies help, and a member officer protocol are definitely part of the range of measures which it is sensible for the authority to have.
Can I just add a couple of points to that? And in some ways this goes to the difference between the Pre-Localism Act arrangements and the Post-Localism Act arrangements. The Pre-Localism Act arrangements had powers where a member could be suspended from the authority, could be disqualified. Now, it had to be done by an independent tribunal, but those arrangements were in place. That was on the basis, really, that the view that a politician is, in effect, like any other profession. I said my colleague who's a doctor here, a doctor can be struck off for gross misconduct, and the Pre-Localism Act arrangement, dealt with it in the same things to say you divorce standards from the ballot box because, something might happen and then the election's not coming up for 4 years. Something might happen actually, are you going to change the way that you voted? If you voted for a political party all your life, are you going to change your way and suddenly vote for a completely opposite philosophy just because you don't like that candidate that's been put because 3 years ago they were a bit bullying to staff at the authority or what have you. So that was the philosophy at the time. What the Localism Act sought to do is to say, actually, politicians are different, that they are elected, and if you don't like them, then firstly, they're subject to party political, regulation, and you could be thrown out of the group or what have you if you do things that, go beyond the pale as far as the party is concerned. But after that, it's then up to, the electorate to express their concern about it. So that's why those powers sees them as different from employees. An employee has a contract and can be dismissed, but then, that their relationship is with their employer, whereas politicians, their relationship is with the electorate, and ultimately it's for the electorate. Now, whether that's right or wrong is open to debate. But that's why the Localism Act and the sanctions are, as it were, because it's saying you have a different relationship than an employee, than a doctor, than a lawyer, than a teacher, whatever, who are regulated separately, but you don't vote. You can't vote your teacher out of office or what have you. The other thing I just wanted to say very quickly is that, again, when it comes to the Code of Conduct and social media, the Code of Conduct, and it doesn't make this explicit in your code, but the Code of Conduct only applies to you when you are acting in your role as a member of the Assembly. So, as Emma has said, if you post a social media posting which is about your work on the Assembly or being very rude about your fellow Assembly members or what have you, that comes within the code, but it doesn't cover, you being rude about a rival football team, and nor why should it. That's a private matter, even if you've described yourself as a councillor. Nor does it cover wider political statements. So you being rude about the government is, that's a political matter. It's not a matter for the GLA because you're not on GLA business. Now, the Committee on Standards in Public Life, again, have made recommendations to the government that in essence, sort of what you might call wider political postings, which are deeply offensive, etc., should be brought within the scope of the Code of Conduct. But that does raise all sorts of difficult issues about freedom of speech. You're perfectly entitled to, the right to offend, etc., etc. So I think it's a very complicated discussion.
And that's the point, isn't it? We're going to keep finding ourselves back at the table of judgment, and it's actually the table's Emma's desk, which is, the position you find yourself in quite a bit. And it was interesting in your answer to Caroline, where you were talking about your approach being rather reactive as opposed to proactive. It's responding to issues that come in, and I think that will probably be different with elected people than perhaps it might be with staff. They might be a bit more proactive there. So thinking about that level of judgment and going back to what we were talking about earlier, well, we've got this form. We say who we are. We say what we do. We say that if we've got any partners, if they have anything that's got a direct relationship. We talk about our pecuniary interests, and then we've got the sniff test box, as was pointed out by the chair, where we say actually we should probably register this. This is the judgment section. We're then at the point of interpretation, aren't we? And that's where there's a real challenge. I found a quote from the former mayor here that says, "I expect that my private life is not in the public domain," and I kind of agree with Ken Livingstone on that. You get to a point where even if you are elected, this part of your life is private. So how do you make that call, right? How do you say, well, this is private, this is public? The idea of a sort of it looked like we were going down the route of having a sort of special friends box or extramarital affair register, which would freak out some people I used to work with in newspapers, let me tell you that. But there's got to be a cut-off point where judgment kicks in, doesn't it?
I think that's part of the challenge here, is this all about judgment, both judgment by members and judgment in terms of how we interpret things. And for me, this is all very serious matters. The GLA has two independent persons who I can involve when it comes to considering complaints that I might receive, either in that initial assessment of the complaint, where I can involve them, and they must be involved if there's an investigation undertaken, so they provide additional support. And then, of course, I can also seek advice from a legal perspective as well. But you're right, it is challenging, and I don't think there is ever going to be an ability to write a code that covers everything, as we've discussed earlier. So.
May I comment on the role of the independent persons? Forgive me, I'm just going to cycle back to the social media very briefly. There is a first of all, are you acting as an assembly member? Absolutely. Secondly, there's a need to balance the right to freedom of expression against the need not to treat others so appallingly rudely that you're treating them with disrespect. There is a line, and there's a very interesting and useful case which talks about, is what you are doing so bad that it disenables, in this case, a member of staff from actually performing their functions. But considerable latitude is actually given to Assembly members when speaking on political matters. And that's actually, there's a bit of tension between that considerable latitude to speak irrationally, excessively, even rudely about political matters, with the LGA's position on civility in public life. And I think we can rationalise that by saying the LGA's position on civility in public life is broadly, if you want to be respected by the public, you need to behave with respect. Because we all know about the increasing concerns about the adverse treatment of those in elected positions. That's an aspiration, that's a should do, that's a leadership issue. But you do actually have the right to say some fairly robust things, and we should protect that and celebrate that right. It's the Speaker's Corner's right. So that is something which will change over time. And that question of judgment and review and discussion about the code, it does illustrate that social, that's why I say the social media protocol should be reviewed on an annual basis, because standards do change. And that review should involve the independent persons to the authority should be part of that conversation. So the role of the independent person is relatively mysterious in that the only qualification is to be independent and to be a person. I have been an independent person for a couple of authorities. Their most important function is to provide views, and they must do so to the authority before it makes a decision in relation to an allegation. But it's good practice that they do so on that vital assessment stage when Emma is actually deciding, what do I do with this complaint? Do I refer it for investigation? Do I not? And that to me is often one of the most significant decisions which the monitoring officer makes. I think it is proper for the monitoring officer to make that, but I think it is, I think I would wish to see a more explicit reference to the role of the independent person set out in the authority's arrangements so that members themselves understood the role, because you yourselves have a right to seek the views of the independent persons, and that is not always very well set out. In most authorities where Paul conducts training, he asks the question to members, do you know who your independent person is? And most of the time they say, we didn't know we had one. So I think they need to be part of the conversation. Lastly, you talked about the exercise of judgment. The authority is unusual in that Emma is the decision maker at the end of the process. That is normally conducted by a hearing panel conducted of members of the authority, with the idea that this is localism, this is peer justice. Only a member can truly understand what it's like to be a member, but with the benefit of the views of the independent person. So I simply observe that the authority's arrangements are not unique, but they are unusual in that Emma has to take all of the decisions all the way along the way. I don't doubt that she's fully able and does so, but if it was me, I think I would definitely be calling on the independent persons to assist me, and she does. And I would be, I think, encouraging you towards considering a panel to make the final decision on investigations.
Yeah, just to add, I think Jonathan's saying not a panel to make decisions on the allegations themselves, but once there's been a formal investigation, etc., it's at that stage when it comes to deciding, we've done a lot of work on this. Has there been a breach of the code? Yes or no? And that's where we think there should be some role potentially for members.
Okay, thank you. Assemblymember Desai, did you have any further questions? No? Okay. We'll now move on to the next set of questions. Assemblymember Prince.
Thank you, Chair. I think the bulk of the questions have been answered, really. But if I could just develop the last point that was being made around how the decisions are made. So, are there really? Would there be a recommendation from you as to how we could improve that decision-making process at the end?
I think the authority's arrangements are ideally they should be capable of being accessible. They should be accessible to a member of the public, to a resident of Greater London. They should be clear to them how they make a complaint. It should be accessible to them on the authority's website. They should be able to see how their complaint is going to be handled. I think that is true to a certain extent. I think however, the interaction with the Mayor's position as MOPAC is really complicated and could do with... I think there is a flowchart to be written. I'm not volunteering to write it, but there is a flowchart that would perhaps might more clearly set out how the the two officers who have policing responsibilities, how allegations in respect of them that could involve a criminal conduct go down a slightly special procedure, which is part of the Assembly's overall ethical arrangements. At the moment, it feels like it's a bit sort of all off to one side. In terms of the end of the process, I feel that I personally like to see perhaps some distinction being drawn between the function of the investigating officer and the monitoring officer. There are situations in relation to straightforward matters where the monitoring officer can be the investigator, where the facts are not in dispute, it's a minor matter. But there are also complex matters where it's quite proper for the monitoring officer to refer a matter for investigation to an investigating officer. Now, questions have been asked of investigating officers as to their degree of independence. It's not here, but in authorities generally. And I think it is helpful that the arrangements spell out how an investigation is to be conducted, to whom the investigator officer reports, when they do so, and how they do so. So that's more of an operational matter. I have particular regard to the judicial review which Alex Salmond brought against Scottish ministers, where the issue there was that the Assistant Director of HR at the Scottish Parliament was involved in counselling staff and exploring with staff whether there were issues to be raised about the conduct of Alex Salmond, but of the then First Minister. That same officer was then appointed the investigator of those allegations. And it was that crossover which the Court of Session considered rendered the investigation potentially at risk of challenge. So I think it is important, it is helpful to set out a protocol for how the investigating officer should conduct their functions, and to indicate that that is a bit different to the person who decides whether there should be an investigation.
Without going into detail, because it might cross over with someone else's questions, do you think that the GLA would be well advised to review its code of conduct and the areas that you've just discussed?
I think it is timely to review the code. Your code has been in place since 2012. I think we've heard that the issues now, new issues have arisen since then, such as social media. Whilst your code is amongst the codes which we would say, Paul and I would say, are fit for purpose, there are some areas which I think we have been exploring today where it could do with improvement. Incorporation of protocols such as social media and in particular other interests would be the two priority areas. As to the authorities' arrangements, which is the kind of under the bonnet, how the engine works, I think those are always things which can be improved and made clearer and more accessible in the light of experience. I would see that as being a relatively continuing process. So I think your code perhaps should be reviewed perhaps every 4 years. The protocols that support it maybe annually, and maybe the arrangements as and when is necessary.
Thank you.
Can I just add some things to that? I mean, clearly, again, we think it would be a good time to look at the code again, because the LGA has just produced a new model code, and one should be looking to see whether actually we just want to adopt that because it's being recommended for authorities, or whether we dovetail the two together, etc. The other thing I should add is that Jonathan and I were commissioned by the Local Government Association earlier this year to write some guidance on case handling as well, best practice around handling of complaints against members as well, which hasn't quite been published. It was delivered to the LGA in August, but it doesn't appear to have appeared on their website just yet, so it's with their comms department. But again, that might be something that you would start at benchmarking against that guidance to see whether there's any gap. And I think in particular, I'd say, having looked at your process, which as was written in 2012, it seems to be written on the assumption that there are no sanctions against members available, and therefore, it's seen as relatively low. I mean, we would argue with that. We'd say, quite apart from, being found in breach of the code of conduct has a very damaging effect on your reputation potentially, and reputation is all to politicians, to assembly members. There are cases and there are a range of administrative sanctions that can be imposed. So there have been cases where, for example, members have been access to council resources restricted, or access to the office when cases of bullying, certain contact with officers, etc. So there are a range of sanctions that are available, and I think that's why we would say, before those sanctions are imposed, it may be something that members themselves would want to take a view on, as it were. So I think that now's a very timely opportunity to benchmark it, because there is that work out there from the Local Government Association.
Well, it's very helpful. Thank you.
Thank you. Assemblymember Cooper, did you want to come in at this point? I had you possibly as next. Assemblymember Cooper, no?
Well, I think my question was really, and I did refer to the business of, there was a councillor who resigned in the middle of a standards investigation, and we don't currently have a standards committee at the GLA. I think possibly because it became very active in considering numerous issues previously. The standard committee, in the list of declarations at the beginning, many of the Assembly members were declared to be councillors as well, and I am one of them. And the Standards Committee in the authority where I sit has a number of independent members who are excellent and put themselves forward and are very involved. And so when issues arise, the monitoring officer goes straight to the independent members, and they consider a lot of matters without troubling all of the members on the issues, and that's the way that it's been arranged. And then there are meetings that then consider a report from the monitoring officer that refers to it's essentially what have been deemed to be vexatious complaints, if you like, and so there hasn't been a need to continuously call meetings of the Standards Committee to consider people saying, I didn't like the way councillors voted on the Planning Applications Committee. Well, obviously sometimes things happen in a committee and you don't like the way the councillors have voted, but that's not an issue for standards, clearly, to all of us who know how those committees work. But members of the public may not understand that and might try and go down the standards route. And so none of those are issues that you would then need to call a committee for, because the monitoring officer is able to deal with them with the independent people. There's a few of them. And I just wonder, when we're having this long discussion about the code of conduct, is it fit for purpose? Can we apply it historically? We're going to think about how we review it. Do you think, considering whether or not we should think about having a standards committee again at the GLA in that new context post 2012 and the changes that happened? The LGA has just been reviewing its own guidance on code of conduct, but I just wonder, should we consider having a standards committee again, perhaps with an arrangement of the one I've just described? Because I don't think committee members assembly members would be keen to be having meetings of a standards committee every 5 minutes, for example.
Can I answer that? As ever with anything, there are pros and cons. I mean, the first observation I should make is that the Committee on Standards in Public Life, in its 2019 report, which it sent to government, said that there should be a reintroduction of mandatory standards committees, because again, there were, until the Localism Act, which removed the mandatory requirement to have standards committees. The other thing I should say is that you're quite right when you talk about the process, and I think what we are saying is that the role of a standards committee in terms of cases comes right at the end of the process. A complaint will come in, and monitoring officer, with the independent person potentially, is absolutely capable of deciding whether anything needs to be done with it, because it doesn't fall within the jurisdiction. It's a purely private matter, or or what have you, or as you say, it's so trivial on the face of it. Somebody tutted at me in a because I spoke, those sorts of things. Monitoring officers are perfectly capable of weeding all those things out. We're talking about right at the end of the process when there's been a formal investigation. The advantages of having a standards committee, and a lot of authorities, when standards committees were no longer mandatory, I'd say about half have kept one, and about half have sort of merged it with things like audit and standards, audit and governance, those sorts of things. The advantages of having a separate standards committee is clearly that it keeps a focus on things like member conduct, and I used to sit on the board of a housing trust where I did sit on the standards committee, and then it was merged into an audit and governance committee, and frankly it just became the audit committee because we never ever discussed issues of governance and standards. So there is a danger that actually the issue of standards get lost. On the other hand, there is a danger you create a committee and it just generates work, or we've got a committee, we better have a meeting, and therefore every 2 or 3 months you turn up and say, what should we discuss? So if you go down the route of having a standards committee, you need to think about what is its purpose. And its purpose isn't just to deal with cases. There is an overarching duty within the Localism Act for authorities to promote and maintain high standards, and that needs to rest somewhere within the authority. It rests partly with the monitoring officer on an operational basis, but it must rest somewhere with the members. So where does that function rest, and what does that mean? And does that mean things like we've talked about, reviewing social media protocol, looking at things like member training in the area of of standards, et cetera. So I would just put that to you. You need to think about. I would personally say, there's a good argument for having a standards committee, but you need to think about what is its purpose, above and beyond simply looking at complaints.
So I would completely endorse, and I've also sat on the audit panel here, and actually the chair of the audit panel is amongst us today, and it's not an area that we consider there, and I can't quite see how it would fit together with audit, and I've also sat on the audit panel in local authorities and also housing associations as well. I do feel it needs its own focus, but I do also completely agree with you that being very clear about what it's going to do. But I was very struck earlier on when I was asking Emma about when we'd reviewed the code of conduct, and I think we established that we haven't really done very much of that. That would be an obvious thing for such a committee, should one be established, to have amongst its remit, along with training on the highest standards of understanding the Nolan principles, or whatever it is that you might also want to bring within its ambit. And I just wanted to bring that out, if that's okay, Chair, because I'm assuming that there's going to be some recommendations will come out of this investigation, and that might potentially be an area that could be worthy of further consideration.
Absolutely. Thank you very much. Assembly Member Fortune, you've got the next questions.
Actually, the question I have has been answered, Chair. So, to provide more time, I will pass.
Okay, lovely. Well, let's move on now to Assembly Member Desai.
Sorry, Chair, I should have come in earlier. Forgive me. Before we move on to reviewing the code of conduct, can I ask you, Ms. Strain, that briefly, what lessons do you think you learnt regarding your role following the IOPC's Operation Lansdowne report?
I think that was a quite challenging and complicated matter. The key thing for me is ensuring that the protocol for dealing with complaints that come under that set of legislation is separate to the Code of Conduct. We have substantially reviewed that procedure now, so it is very much a clearer document in terms of the responsibilities I hold and the process that we undertake. And I think that, for me, is the positive thing that I take away from that process, that protocol is now fit for purpose, and it ensures that the PCC are kept very closely aligned to any matters that arise going forwards. The protocol associated with any complaints that fall under that piece of legislation is now a much improved document to it was a couple of years ago. So we've now completely rewritten that document, which means that there is a much clearer process for me to follow, and a much clearer process in terms of how I engage with the Police and Crime Committee on things that fall into that matter.
Yeah, I just want to clarify that. So I think maybe with hindsight, but although you have delegated authority for decisions regarding referrals to the IOPC related to conduct of Police and Crime Commissioners of London, do you now accept that you should have informed the committee of your decision through the chair before referring Mr. Johnson to the IOPC.
I made a statement.
I think you made an apology.
I made a statement to the PCC in June last year, and I apologise for the fact that I didn't involve them earlier in the process.
Yeah, no, I think the committee accepted that, and
they did.
And this is not to go back over.
No, and I think the important thing is
but just to let things formally.
Yep. And the important thing is that protocol has been properly updated to ensure that it's much clearer now, and that actually going forwards, that the committee can have confidence in that matter.
Chair, that's it. Thank you.
Thank you very much. Let's move on. We've already touched on the review of the Code of Conduct, but we might want to pick up a few other questions. Assembly Member Best.
Thank you, Chair. Emma, sorry, it's nice to hear my name so much and I'm not the one in trouble.
You can swap anytime you like.
You've answered many of the questions, I think, where there's been some overlap into the review of the Code of Conduct. So I'm going to try and make it as succinct as possible and just really focus on what changes are you considering making from the review so far, thus far.
So I think we've spoken extensively today about interests. We've touched on social media. I think to pick up on some of the points Paul's made, I'm quite sure there's a lot of good information and analysis that we can gain from the work that Paul and colleagues have done on the LGA's review and their model code of conduct. So that's an area that we need to look at. There's also the work from the Committee on Standards in Public Life and the recommendations they've made. We would be looking at those as well. So I think taking those things plus the work on interests and standards, interests and social media is important. And then I guess there are some sort of other things that exist in the GLA that we could think about whether we should, to use Jonathan's words, have regard to. So that includes things like cyber security, perhaps digital safeguarding. So there are some other topics which we can look at and consider whether they should be referenced as well. Those are the kind of key areas that I've identified thus far. But obviously the work of this committee is really important, and the findings of this, I would take on the findings from this committee into that review and then perhaps bring that back at a later stage.
Thank you.
Assembly Member Hall.
Again, you've answered many of the questions within your extensive other answers, so thank you. Just one here. To what extent does the local or the LGA's Model Council Code of Conduct apply to the GLA?
I'm going to ask Paul, because Paul has been the lead
Paul.
in terms of drafting it.
In theory, it should apply. It should apply totally to the LGA. I mean, again, we were to the GLA rather. We were writing the code so that it is applicable to all councils, if I can say this, from the GLA down to the smallest parish down in Cornwall, because standards should be universally applicable. Why should a member, in West Yorkshire where I live, be treated differently to a member in London, etc. Yeah. Okay. I mean, obviously there will be bits that one has to look at. Maybe modular, because, for example, if you're putting a provision on an elected mayor, there isn't an elected mayor in a lot of authorities, etc. But broadly, the code is meant to be applicable.
Good. Okay, I understand that. Thank you. Thank you, Chair.
Okay, lovely. Let's move on to the next section. I would start this is just trying to benchmark our code of conduct, and we've talked about where it's weak, where it needs to be strengthened. Obviously you've talked about your model, but what is best practice? Where can you name local authorities that you think really are leading the way on this and have best practice in terms of reporting both pecuniary and the non-pecuniary, those other personal relationships, those personal interests? Jonathan, Paul.
Our answer would be, of course, that having worked on with the LGA to produce the model code of conduct, we have attempted to draw into that examples of best practice across the board. And I will pass to Paul in a moment. Specific additions that we brought into the LGA model code of conduct was a provision dealing with harassment as distinct to bullying and disrespect. We had some considerable discussions about was there a difference between harassment, bullying and disrespect, but concluded that they are conceptually potentially different. Bullying is normally considered to be an exploitation of a power imbalance, disrespect is normally considered to be conduct which is unwarranted, unreasonable and personalised and could be a single incident. Harassment can be a drip feed and is particularly important, not of less relevance to the Assembly, but was particularly important to the town and parish sector, where a parish clerk may have an outwardly healthy relationship with a parish council, a small parish council, but actually by their conduct of perhaps being emailed, the contents of the emails may be entirely proper, but it's the fact that they're being emailed at 2 o'clock every morning. So that might be an example of a persistent conduct which outwardly is acceptable, but in its effect results in harassment. But of perhaps more of interest, direct relevance to, I can't remember whether it was Assembly Member McCartney who referred to training earlier on. So we have introduced a part of the code which imposes a requirement to attend member training, because we consider that members should commit to their professional development, and that attending training is part of the essential toolkit to being an effective member of a democratic body. So that is an example of something which is new, which we have put as a proposition in the LGA Model Code of Conduct. But if I turn to Paul for any other areas.
Do you have any examples of councils that are doing this well?
I'd say a number of things. I wouldn't want to name specific councils to say they've got good practice, not least because I once worked in the civil service where we awarded beacon status to a council for its education service and then found an hour later they'd just been put into special measures. So if I said to you this council's brilliant, I will probably get home and find a headline to say oh, it's all gone wrong. And sadly in my role I tend to see, I could tell you the ones which probably have bad practice but not necessarily good practice. When we looked at the LGA code, for example, we did do a review of codes of conduct and there's lots of really good codes of conduct there, but they all follow broadly the same model, and we've tried to build that within the LGA code of conduct. And
the model code is where to go, which
yes,
is the best
yeah. I mean, we would say that we did that by first of all reviewing codes from local authorities generally. We also looked at the codes that applied in Scotland and Wales, where they still have a national local code, as it were. There's a national code that applies. We also looked at codes from other professions to see what common lessons there were, and broadly, the good codes all go down this fairly simple set of rules. Do not do this, do rather than getting into a very complicated language. I think the more important thing where one would look for good practice, as I say, is around the wider promotion and maintenance of standards, because as I said, you can have the best code in the world, actually it doesn't mean anything if you routinely ignore it, or you can have the best case handling process, but that's fine if it's not followed. And again, I'd be very happy to talk to officers outside this I'll give it some thought about where there are good examples that you might want to they might want to talk to about promotion, maintenance of standards, monitoring officer to monitoring officer, as it were, if that's okay.
Lovely, that's very helpful, thank you. Assembly Member McCartney.
I think most of my questions have been answered, but I have one, and that is, we talked earlier about the current legislative framework. Is there anything that you would like to see in a code of practice that you're not allowed at the moment and would require a legislative change?
I think I would go back to the recommendations the Committee on Standards and Public Life have made to government. The committee did its report in January 2019, and it's still awaiting, two and a half years later, it's still awaiting any formal response from the government. And I think they made a number of recommendations, and Jonathan and I advised the committee, so some of the stuff reflects our thoughts on that. I mean, the key area, I think, which every submission practically to the committee made, and indeed every submission when we consulted on the Code of Conduct, even though it's nothing to do with the Code of Conduct, was about there need to be some form of sanction which allows at least some sort of temporary suspension for the most gross misconduct. And I think that would clearly need legislative change. I think the other difficult areas which we've touched upon again is this issue of, you know, the interface between public and private. And I think, you know, again, that always evolves because things like social media have made the area much greyer. You know, the 24/7 news agenda, people don't really retreat behind their doors as much as they used to, maybe. So I think that's an area that would need legislative change, but again, raises all sorts of difficult, complex questions, you know, around that interface between freedom of speech, between the right to a private life, etc. But, you know, those are the issues I think that need to be wrestled with at a sort of national level.
Okay, Mr. Goulden, do you have anything else?
I agree with Paul that the universal cry across the sector has been to call for limited power of suspension, recognising that that would be a sanction to be exercised in the most serious cases, because it underpins the credibility of lesser sanctions. But also, it was the key message from the sector that actually this should be characterised by localism, that it is for each authority to determine what is appropriate to it in terms of its own culture, and whilst we might have some common understanding of universal standards, they are to be applied within this particular governance circumstances. I found, and I'm sure Paul will agree with me, that what members regard as being acceptable language in one authority can vary very differently to another authority. And, you know, to use, you know, I moved from Yorkshire to Derbyshire, and members were equally passionate, but showed that passion in a different form of language. So I think it's important. And for London, you know, it's important that the entire focus of the Assembly and its actions reflect the diversity of London. And that means that you will have regard to some different norms and cultures which might not be as immediate to another area. So common standards, a power of suspension, but within a localism context.
Okay, thank you, Chair.
Assembly Member Desai, I think your last one has been answered. I don't know if you've got any other questions.
Mr. Hoy did talk about freedom of speech. I was just going to ask you whether you could elaborate on that in terms of any particular challenges, but also just generally looking at bringing everything together. I don't think any more questions after this. I mean, what can elected members, you know, reasonably expect from benchmarking of code of conduct? And particularly, I think the issue of civility, which is a two-way process as well. The code of conduct is all elected members, but also how we get treated as well, by members of the public.
Yeah, I mean, I think what I'd say about the code of conduct is, I mean, when we looked at the code of conduct, we looked at, you know, who's the code of conduct written for? Is it written for members to help them do their job? Is it written for the public as a contract to say, you know, this is what you can expect from your elected members? Is it written for officers who have to interpret the rules? You know, and clearly it's a mixture of all those sorts of things, and that's what we were looking for. But I think ultimately the code of conduct is there to protect councillors, because, you know, again, often when I talk about terrible things that councillors have done. I have to recognise that's 1% of councillors, you know, 99% of councillors that I meet up and down the country, regardless of political badge or whatever, are just there to do the best for their community in incredibly difficult circumstances, get an incredible flack from the public, etc., and, you know, and they just want to say, look, we want standards, and we want clear rules. We want to know where the boundaries lie. We see the code of conduct as there for the 99% of councillors to actually say to them, it's a protection for you, because you can point to those rules to say, look, I don't get involved in these issues because there are specific rules which say, you know, I don't use my influence improperly, etc., etc. So I think it's quite important that the code is recognised. It's not there as something which is to punish councils is, but it's as much about there to say, you know, we are open and transparent in the way that we do business. Just on freedom of speech, it's a very difficult issue, because, and again, some of the work we did with the LGA, you know, we showed one political group, here's some comments which are made, you know, which a Conservative councillor has made about, you know, the leader of the Labour Party in fairly insulting tones, and they go, that's outrageous, that should be regulated. And then, of course, when you show the Labour Party things that somebody said about, you know, the Conservative Prime Minister, they go, well, that's perfectly acceptable. And it's very difficult to, you know, what is and isn't allowed within robust political debate. But what we would say really is that it's about a lot of it is about self-policing, but a lot of it is about setting the tone within your organisation, within your culture. You know, Jonathan said, you know, language will vary from up and down the country. I'm from Liverpool originally. You know, there is quite a lot of industrial language, but they know when things have crossed the line, because there is a you know, they set their culture within there. You know, so you can knock lumps out of each other, but it doesn't get into personal, you know, attacks on, you know, people's protected characteristics and things like that. And I think it's very important that the Assembly, when it looks at that, sets the tone and says, this is what we expect from our members. This is the sort of language we expect our members to use. This is the sort of standards that we accept. I think reflecting on the Code of Conduct is a good opportunity for you to, you know, to set the benchmark yourselves. And whilst there's guidance out there from the LGA about what it might mean, it has to be seen in the context of your Assembly, and, you know, what is and isn't acceptable for the members within this room.
Thank you, Chair.
Thank you. Can I just pick up one final thing? We talked earlier about refresher training for members. What's best practice? How often? Should it be at the start of each term, or should it be every couple of years? What would be best practice?
From my experience of what I would say is really best practice is certainly the training that we do. When, you know, whenever there's an election, and some councils that clearly elect by thirds, and et cetera, is that there is a programme put on which is not just for new councillors, but it's training for all councillors, you know, so that they go, and that might be once a year, it might be once every 2 years, once every 3 years, you know, for example, on the Code of Conduct, which is what I train. The very best authorities are that, you know, that's fine, you can put on training. If people don't come, you know, what can you do about it? I mean, Jonathan has said, we've put within the code, you must attend training, but ultimately you can't force people to attend training. And I did a training this week for a council where, you know, the member it was ostensibly aimed at actually didn't attend the training. But in some of the, you know, the best authorities we work with, actually, again, the political leadership take control of that. I know one council, for example, which, you know, each of the group leaders says, well, give me a list of who hasn't attended the training, you know, and bring that list to the council meeting every month or whatever, and we will read out and saying, here's 3 members of my group who haven't been to the training. I expect them to go to the training before I put them onto a committee. I expect them to go to the training before, and gradually deal with that, because I think, you know, it's all very well having a training programme, but you need to make sure that it's enforced, and you need to make sure, and that comes from political leadership at the top, I think.
Lovely. Thank you very much indeed. Well, that comes to the end of our questions this afternoon. So thank you very much indeed for answering our questions today, and for your time, Emma, Jonathan and Paul. We really appreciate that. We've got a couple of items of business before we finish. Just can the committee note the reporter's background to put in questions to the invited guests? And guests on the Code of Conduct, so I've just been passing, and delegate to me as chair in consultation with the deputy chairman and party group lead members to agree any output from this meeting. Can we agree that? And just very quickly, item 7, our Oversight Committee work programme. Can we note our work programme for 2021-22? And the date of our next meeting. Members, we are back here 2 o'clock next Wednesday afternoon. This will be the place to be. Clear your diaries for the afternoon. I think we've got a long session ahead. And any other business that's urgent, I haven't got any, you'll be pleased to hear. So thank you, members, and thank you again to our guests for attending this afternoon.
Thank you, Chair.